early because the Kahoot is a little long.
Yes.
Hello, everybody. Excited to have you in class today. Today's class is on the Bill of Rights. It's a great topic. We're looking at our first 7 amendments, how they came about, why they were at it, where the ideas came from, and then what are they, and then how are they in play today. So we have a lot to do in 30 minutes. And my name is Kerry Sautner. I'm going to be your host, your guide, and your chatty person in the chat with you as we go through this. But I'm joined, thank goodness, by one of our top scholars at the National Constitution Center, Nick Mosvick. So Nicholas, say hi, and I know you can't wait to get started on this Kahoot.
Yes, I'm excited for the Bill of Rights. I'll make no declarative statements about the Kahoot.
He loves the Kahoot and he's going to use it at the next family function. So here, everybody, I'm going to put the Kahoot up so we can all see it together. And if you don't know what a Kahoot is, it's kind of a simple, fun online game. This is on our website, and I will share let me get this straight. This is what took me a minute to figure out last time. I will share the link with you. So if you want to do this later tonight with your family at the dinner table, or with your students in class, or with whomever you want, you can do this as well. So the way you do a Kahoot is you go to kahoot.it, and then you put in the PIN number. And when you put in the PIN number, your name will pop up there. If you don't feel comfortable opening this up, no problem. We can go through the game, and you can also answer in the chat. So waiting to see if we get any players on the actual Kahoot from our group. And we will give you guys 1 more minute. Emily, aren't you going to go on? I will share in the chat that link as well.
Just put the pin in there.
Oh, thank you, sir. Parker, awesome. And that's not my kid.
I was going to ask her.
No, he would not be playing a Kahoot, I don't think.
No, you've apparently had enough Kahoots at regular family dinners.
That was the adult table that did the Kahoot.
Sure.
Okay, we'll give everybody 1 more minute. Parker needs some kind of competition in that Kahoot, but we can go through the questions as well. I'm just going to shrink this so it's not so big. Paul, thank you, Paul. We've got competition. Here's the link for if you want to play it later with your students. So let's get started. Okay, and again, if you don't have Kahoot up, no problem. Answer in the chat. Nicholas is going to be working the chat right now for you. So let's get started. The fun part of doing it on Kahoot is you can actually hear the cool music. So how many amendments are in the Bill of Rights as it's ratified in 1791? This should be a fun, easy answer for you guys. Are there 8 amendments, 12 amendments, 10 amendments, or 15? Once it's ratified. Very good answer.
Yes, and we're saying it's a trick question there, because I said this last time, because 12 were given to the states, but 10 were ratified.
Awesome. Thank you, Nick. Right? Nicholas is going to add our commentary as we go through.
I feel like this is sports. So
good. I love it. Who is the primary author of the Bill of Rights? Don't worry, people. It gets harder. Is Thomas Jefferson, Alexander Hamilton, James Monroe, or James Madison? Very good. James Madison is the primary author.
Yeah, as I said, my man, right?
There was a lot of guesses earlier today for Thomas Jefferson. He wrote the Declaration of Independence.
But he really wanted a Bill of Rights, is what we said.
Yes, he did. You're right.
He wrote to his friend James, so he was pushing for one.
Which right isn't guaranteed in the First Amendment? Freedom of speech, freedom of the press, freedom of assembly, or the right to bear arms? Very good. Right to bear arms is not.
They know their First Amendment. Do they know the other 2 parts of the First Amendment not listed there? There's the question, right?
Go ahead, Nicholas.
You got the rest? Well, the missed petition, that was the one that I complained about this morning, but there's religious freedom there too. So
awesome.
We'll get to
Nicholas,
both.
What amendment is the right to bear arms?
The Second Amendment.
Very good. Okay. And it depends how quickly you answer, you get extra points for that too. What is the Third Amendment all about? Soldiers occupying your home, right to attorney, right to privacy, or right to a trial.
Now I think about this is a bit of a trick question. Because one of these is partially true.
Okay, so you're going to go with half credit if they get the partial one.
That I will give them half credit for saying the right to privacy.
Thank you, students, for getting the the direct answer is soldiers cannot occupy your home because of the
Actually
Third Amendment.
true, but as a matter of the background in interpretation, the right to privacy could also be considered.
And I think that is a great segue.
Rational.
To Akil is going to be here this Friday, and he will also.
We're taking from him.
That.
I didn't even mention this at noon, but when we talk about the Second and Third Amendment and the Ninth and 10th Amendment, we steal from both Akil Marr and Kurt Lash. But that's because they're good scholars
and they're great writers
who know how to put these things together, and that's why we think of the Third Amendment as part federalism, part privacy.
So Nicholas was talking during this one. Does the original Bill of Rights protect you against cruel and unusual punishment? Yes, it does. Right answer, everybody. And which amendment is that, Nicholas?
It's the 8th Amendment. We're going to get to the rest of it later because that's only one component.
And Parker's movie.
There's that excessive fines and excessive bailment part that's important too.
Double jeopardy, self-incrimination, and due process are all critical parts of which amendment? The fourth, the first, the fifth, or the eighth?
And it's just, you're missing my favorite part of this amendment.
Sorry. You can say, and what?
The grand jury clause? They weren't, what? I don't. No, I know you were thinking the taking clause.
We're going to definitely make a harder
get to
quiz.
Both.
We're making a harder quiz next time we do this for the advanced class.
Yes.
7 out of 11, the original Second Amendment, or you can say the second article, wasn't ratified in 1791. It later became the 27th Amendment. How many years is that? So quick math question for you. They're
going to get this. They're going to get
10,
this.
103, 150. Yeah, if you can do it by deduction, guesstimate. You don't even have to be that great at math. 3, 2, 1. Nice. 203 years. Thank you. 203 years is the correct answer. Okay, next question. 3 more left. James Madison's state made the Bill of Rights official when it ratified in 1791. Which state is that? I know Warren can answer this in the chat, and so he better be answering it. Was it New York, Connecticut, Virginia, or Maryland? Which state is James Madison's home state? Virginia is James Madison's home state. I get New York. There's a lot of big, important delegates from New York. Hamilton loved New York, wasn't from New York, but loved New York, but was Virginia. Okay, Parker's still in the lead.
He did go to college in New Jersey. I mean, you could set that.
Where is the original federal government's copy of the Bill of Rights today? This is absolutely a trick question, but do your best to answer it. Is it at the
only because of that the word copy was. If it's just the federal government's original copy, that's
so
where that's
I hate the word original when we talk about documents. You guys are right. It's at the National Archives, but the National Constitution Center does have an original copy that went to the states of the Bill of Rights,
which is not the federal government's copy, which is why that's in the National Archives. That's a statutory answer. That's a legal answer.
It
has to be there.
Okay,
that's what the National Archives is made for.
The 10th Amendment deals with a relationship between what two groups? Congress and the president, federal government and the states, the Supreme Court and the military, or the United States and Canada. That one always makes me laugh.
It makes me laugh too.
Federal government and
in fairness, we did consider invading Canada numerous times, so
we like to find lots of right answers everywhere. Okay, last question. The original Bill of Rights covered abuses by the national government, the state governments, or both the national and the state governments. The original Bill of Rights. Ooh, such a good split.
But as I said earlier, though, the John Bingham answer is potentially there was a plausible argument by some that it did apply to both. That was the John Bingham argument. So that's our author of the 14th Amendment who thought he was rectifying a wrong that was based on interpretation, not
so technically the technical answer would have been the national government, but after the 14th Amendment, it would have been the national government and the state government.
According to John Bingham, yes. We always have to say that because, of course, even that was and is an open question, which is the question of applying the Bill of Rights to the states, which is what we call the process of incorporation, which is its own separate question. But there's the text, as we'll go through them, of those early amendments. Some of them specifically say Congress shall not. So there's the text component that makes it also difficult because it suggests that it only applies to the national government.
So, Nicholas, now that we had a fun quiz to kind of get our brains moving and running, one of the big kind of key questions that we have for this class is, we want to go through all the amendments. We want to look at a modern hypothetical and make sure we dive into how does this play a part today. But really, let's start with, where did they get these ideas from? When we think of the founding generation, they had just ratified a constitution, and then they quickly add a Bill of Rights. Is that an afterthought? Are they connected? What's the deal between the Constitution and the Bill of Rights? And kind of give us that founding story. And did these listing and writs of rights come out of the thin air, like the beautiful air above my head? Or did they did they have precedent? Were there ideas before that? So can you give us the founding story? And then we're going to dive through all these amendments, what they say, what they mean, and then dive into, let's put it into practice today.
Yeah, so the precedent is certainly there, and there's two primary precedents that are really important. The other component, we'll say, leads us into the actual debate we get into between 1787 and 1789 about whether or not there should be a federal Bill of Rights. But what's the precedent? So there's the English one. I mentioned this at noon, but the Magna Carta, the degree to which it's a Bill of Rights, it may or may not really be one, because it's largely made between the king and his barons, and it has to do with the recognition of the crown of certain rights. But due process, this notion we have, goes back to the Magna Carta, this idea that the government cannot arbitrarily infringe upon your rights without reason. So due process, we put that there. We go forward to the 17th century, and English history in that period is a lot is going on. There's a civil war. There's the beheading of a king. There's the restoration of the king. And then there's finally parliamentary supremacy that happens after the Glorious Revolution. Well, when Parliament does that, they also pass something called the English Bill of Rights and the Declaration of Rights. Essentially, what Parliament does is to list all the rights that the king had infracted over time. Right? It's a list of grievances, which it's kind of like our Declaration. And what are those grievances? What are the kind of rights that they're talking about? Well, they include things like the king had no right to suspend or dispense with the laws without Parliament's consent. So the king shouldn't have suspended Parliament. Subjects have a right to petition the king. So there's that right of petition. It's actually pretty important. No standing armies in times of peace. The right to carry arms suitable to their conditions and allowed by law. No excessive bail or cruel and unusual punishments, exactly that language of the Eighth Amendment. And then freedom of speech, but within Parliament. This is actually an interesting thing. The first declaration of the freedom of speech was about legislative speech. So we're not talking about sort of this broad notion we have today, but we're talking about sort of this legislative debating form of free inquiry and speech. So that was that English Bill of Rights that is really that first written declaration. Then we get to 1776 and we get to the states. And not all the states. This is an important fact because Federalists will bring this up, right? Alexander Hamilton, James Wilson will mention this. Not all state constitutions had a Bill of Rights or a petition of rights or a declaration, but some did, and some were pretty influential. And Virginia's was arguably the most influential. It's why some call George Mason, who wrote it in June 1776, just before the Declaration of Independence, is sometimes called the father of the Bill of Rights, because James Madison looked to the Virginia Declaration of Rights for a lot of what he wrote down in 1789, because a lot of those basic rights we think of were there in sort of their infancy, right? We might say. I mentioned this at noon, Kerry, but I'll say it again because it's helpful to everybody. If you go to our interactive Constitution, you can go to those Bill of Rights, those first 10 amendments, and you can see the earlier state versions and compare them side by side with both the drafts in 1789 and then the final language so you can kind of see how we get to where we get to. But that's how you know things like the First Amendment was influenced by freedom of conscience, because George Mason's version specifically talks about freedom of conscience, right? They talk about things we have in the Fourth Amendment, like protections against unreasonable search and seizures, against general warrants. So the protection of freedom of speech, conscience, religious rights, all these things that are in there. So it's not the language that we have in our own Bill of Rights, but it is deeply influential in terms of what were thought to be the fundamental rights that need to be protected. So maybe that's the best way of putting it, right? Is they give us an idea of what those are. The other one is the right to trial by jury. So that kind of takes us to the Constitutional Convention and how we actually get to the Bill of Rights. But if you want to put another question forward, go ahead, Kerry, because I think...
Yeah, I think I just found it really interesting that we look at the English Bill of Rights and we hear so many of the same words and ideas. We see them reverberated and repeated in some of the states. And so it's such an interesting process because we tend to act like it was like down, given as like a pop-up moment, like a light bulb went off and they're writing down these Bill of Rights. And it's really not. It's really like to say this is a continuum of what people believe are base rights, that the government shall not do it, and then in it, like additions and tweaks to it. So they get
it's a dialogue, right?
So I guess this is where I get to the convention question.
Yeah.
So if it's so darn important and it's so essential and it's been a part of, so many people's lives coming into the convention, why isn't it a part of the actual Constitution writing? Why is it separate? And Greg kind of asked that question there, like around that. Greg's question is, why is Congress, the executive branch, and judiciary and the courts in our Constitution are ignoring our Constitution and our declaration? Oh, Greg, I'll pull that in towards the end. I think that's a good question for the end. But why are they, if they're so fundamental, why didn't we weave that into the constitutional writing in the long, hot, sweaty summer?
Yeah, so there's a couple components there. One is I'm eager to use the Hamilton answer to that because he really does essentially, I think, answer that very question, which is a good one. But for the convention, why don't they do that? Well, I mean, so we talked last week. We know what the convention was spending a lot of time on, right? Representation, the presidency, the issues of slavery are rolling in there. There's a lot going on, and it is a long, hot summer. And they don't bring it up till the last week, really. That's the whole thing, right? Is that we talk about these dissenters, George Mason, Edmund Randolph, and Elbridge Gerry, who refused to sign. And they bring this up in the last week of the convention. And by this point, they've settled a lot of those long-running issues, right? Finally. And you have to think of that kind of like exhaustion of, in the words of Ben Franklin, that, look, this isn't perfect, but it is a good constitution and we should support it, right? And so that's that kind of sense of, we have been brokering this compromise for months. We've been working on this. Really? We're going to do this now? And so, yes, Mason brings it up. Gerry wants it. Randolph wants it. It doesn't go anywhere. Ultimately, they're going to submit that Constitution to the states on September 17th, right? They agree to it and sign to it. Those three dissenters refuse, and they make clear publicly that no Bill of Rights was a big part of that, right? They have other complaints, mind you, but the lack of a Bill of Rights is a big one, especially for Mason. And so that kind of sets off the ratification debate going forward, right? Is it starts on this note of, what was the problem for those who didn't sign and for those who now oppose it? Well, one of the big problems was the lack of Bill of Rights. The other was that they thought that state governments were giving up too much power and the federal government was giving too much. In other words, not only do you need a Bill of Rights, but you need structural limitations on the power of the federal government. So that's the anti-federalist complaint is there, right? There's too much power given to the national government. And all these important fundamental rights we know that the states protect are not protected by this new constitution. We're worried about that. So what's the response? So I started off by mentioning that, but yeah, there's a response. Two figures give their best response. So I'll mention that Madison himself, he has a discourse of letters with Thomas Jefferson, who's in France, and Jefferson is telling him, yes, we need a Bill of Rights. I really think that we need one of those before we ratify. We need to work that in there. And Madison is not keen to it. He doesn't really think they need a Bill of Rights. James Wilson in Pennsylvania is one of the first to really give an answer in October of 1787, essentially right away. And, Wilson is saying, well, okay, so the new Constitution is built on this idea of limited enumerated powers. In other words, the government is given certain powers. And yes, within those powers, they have a lot of power, but they're limited. And so therefore, the people through the Constitution have not given them the power to, say, regulate free speech or to establish a national religion or to quarter soldiers in the home or anything like that, right? It's, in other words, having a Bill of Rights would imply powers that don't exist. Hamilton takes that argument and I think explores it even deeper. So if you look at Federalist 84, which is one of the final Federalist papers that, you remember the Federalist papers are written during these ratification debates to convince people, especially in New York, to support the Constitution. And what Hamilton says is not only is a Bill of Rights unnecessary, but it is in fact dangerous. What does he mean by that? Well, he means that if you imply that the federal government had some sort of power to stop newspapers from printing a story, to suppress freedom of speech or any of these other things like establishing a religion or regulating the rights of criminal defendants, quartering soldiers, whatever it would be, none of those powers are given. So what Hamilton's point is that those don't exist. This is a government and limited powers. And so what does that mean? He's saying the Bill of Rights is the structural constitution. Don't put in a Bill of Rights with a list of a couple of rights, which, by the way, he would say implies there's other rights that aren't listed that aren't protected. That's not good. But the point is the structure of the Constitution itself, based on popular sovereignty, we the people give certain powers to the government, but not others. We retain our rights. That is what actually protects liberty and freedom. And it's not surprising for Hamilton to say this because he makes this argument throughout the Federalist Papers. His point being is do not be scared of a stronger national central government, because that actually is what protects our freedom and liberty, not what he would consider parchment, right? This notion of a piece of paper with listed rights is not what protects you. What protects you is these other structures that the Constitution will grant you.
Sounds a little like Bigham there.
That's the Federalist persuasion, right?
Yeah. Mm-hmm.
So that sets up your debate, right? And so that explains to you why, in their minds, this didn't need to happen. So your next question is, how did we get there? Right? How did they persuade them? Well, this was a solution to the fact that anti-federalists actually, there was a lot of anti-federalists. And in some of these state ratifying conventions, the vote was pretty close. So that's Pennsylvania, Massachusetts, Virginia, New York. In some of these states, it looked like they might not ratify the Constitution. And they ended up ratifying what we would call conditional, meaning that, yes, they signed onto the Constitution, but then they said, well, we want these amendments. We want you to consider a Bill of Rights. Here's a list of the rights that should be protected. Do this, right? And then New York and Virginia actually put out a letter saying, hey, other states, let's have another constitutional convention. Let's come back together because they had that first one in secret and they made too strong of a national government. We don't like it. And they don't even have a Bill of Rights. So we're going to get back together and we're going to fix all those things. Well, Madison is going to see that and say, yeah, that would be a really bad idea. We don't know where that would go. We don't even know that we'd get another constitution. We don't think it'd be, how do we know it'd be anything like the one we have, which we like? Mm-hmm. We have to avoid that. The other thing, as I mentioned at noon, is he's also running for office. Yeah. He's running against an anti-federalist. Yes. Yeah. Anti-federalist James Monroe, because Virginia legislator was anti-federalist. They got to appoint the two senators under the original Constitution. So Madison could be a senator. So he ran for the House seat against James Monroe, who had been an anti-federalist. He opposed the Constitution. And Madison made a promise to the people. And he said, look, one of the first things will do in the first Congress is to submit a Bill of Rights. And Madison does hold to that promise.
Yeah.
Even Washington himself in his inaugural address says we need to have this. So Madison gets working on that project. But from his standpoint, it's a political solution, and not just in the cynical sense, in the sense that he thinks we need to get these anti-federalists invested in this project of union and of this Constitution going forward. How do we do that? A Bill of Rights will help to do that. It will be a unifying venture that we can all find reasons for supporting. So Madison is seeing it that way, right? He doesn't originally support it, but then he understands why it might be important.
And I actually love Dickinson writes at this point in time, and he's saying, look at your Federalists, look at your anti-Federalists. These are people that care so much about the country that they're willing to engage in debate.
Yes.
And that we should, as we go to this next phase, embrace everybody and see that as the best kind of citizens. I absolutely love what Dickinson kind of pulls it in. And this is what Madison does. Now we have a listing of the first 10 amendments here when we look at all these, and we're going to fly through them because we've got like 4 minutes to do this. But just for fun's sake, when we talk about the First Amendment, this is not the First Amendment that's written and goes out to the states. This is the first article. The First Amendment is actually Article 3, correct?
Yeah, that's the whole thing, is that Madison actually has, Madison and the House have 17 draft amendments they send to the Senate. And then the Senate edits them and sends back 12. They reduce them. Madison is not happy. Many of the allies are actually even more upset, but ultimately there's a joint committee. Their familiar names, including Roger Sherman and Oliver Ellsworth, are on there. The compromise, and to get language they can accept, that's what they send out to the states. So it's not even the original amendments that Madison himself wrote, but there's 12 of them that get sent out there. 2 of them are not ratified. One of those has to do with the scheme of proportionment for the House, which is still unratified. And then the other one is the one that became the 27th Amendment, which has to do with increasing the salary pay of those in Congress. And so that took 203 years, but wasn't initially ratified.
Okay, now, Nick, we're going to put you to the test.
Yes.
We're going to see how quickly you can fly through these Bill of Rights. So you're going to
do the last time, we'll do it again.
Yes. Big ideas. First Amendment, go.
So I think we already mentioned some of this, but this is the freedom of conscience. So when we went back to the Virginia and some of the other state constitutions, that make that fairly clear that consciousness is what we're talking about, in the sense that your ideas, your beliefs, your thoughts cannot be alienated or given away to the government, right? This is among those inalienable natural rights listed in the Declaration of Independence, is that right of consciousness. And therefore the First Amendment freedoms listed reflect that value, right? So religious freedom, freedom of speech, freedom of the press, and then both assembly and petition. And reminder, right, I said that petition is mentioned in that English Bill of Rights. Petition was a long-standing right that was thought to be essential. So that's pretty important there too. The Second Amendment, I think the core here is self-defense. So whatever we make of how that means an individual right to bear arms in terms of our modern Second Amendment, because there are 2 components in this text. There's the well-regulated militia, and then there's the right of the people to keep and bear arms. The central value here is self-defense and kind of the question of who. So that's the Akil Omar, is that this is a federalism provision that has to do with state versus federal power, but in any case, it is about self-defense. The Third Amendment, Akil Omar would also inform us here too, is there's a federalism component here that say that the federal government cannot put soldiers into your home in times of peace without your consent, right? There is a privacy part there, but there's also a power component. Who can't do that, right? Mm-hmm. And that, of course, went back to that colonial experience under the English and the Quartering Act, in that sense that that was a deep invasion of rights. Therefore, government can't do that. And specifically here, they were originally thinking of the federal government. That's what I mean by a federalism provision. Fourth Amendment, core here is the objection to general rights. So we often talk about the story of 1761 and James Otis in the
General
objection
warrants.
to general warrants, right?
Yeah.
And so that sense that if the government is going to search you or your home or your things, that they need a good reason to do so, generally speaking. So that's what we're thinking of there.
Do it. Good reason. Fifth Amendment.
Fifth Amendment. There's, as I said last time, there's a lot going on here. So it's hard to say there's a theme to the Fifth Amendment, but it's mostly criminal rights. So that question we had in the quiz, the kazoo, gave you a couple of those, right? So we're talking about double jeopardy. You can't be charged for the same offense more than once. Self-incrimination, right? So the right to remain silent means that you don't have to say something, but if you do, then you can be examined. There's the due process, right? Deprived of life, liberty, or property without due process of law. Due process provision is in there, so that's important. There's also the takings clause. So government cannot take private property for public use without just compensation. So we also think of that as eminent domain, with the limitations on what the government can do with your property. The Sixth Amendment is, I think you put this well last time, that the Sixth Amendment is, these are process rights. So the Fifth Amendment has some of those too, but then the Sixth Amendment, we see these are all criminal defense process rights. What are considered to be the fundamental liberties of a criminal defendant? It's the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, meaning that you have to be tried by your peers, right? That was always considered an important part of the right to a jury trial, was that also you be tried by your peers as opposed to like a judge or in a faraway land. You have to be
the Sixth Amendment is about being fair. If you have to go
fairness, exactly.
If you're charged, then you better have a fair way to go through the process.
And so that goes to the next piece, right? You need to be informed of the nature and cause of your accusation. You need to know what crime you've been accused of and why. And you need to be able to confront the witnesses against you. That's the confrontation clause, which typically means being able to cross-examine people on the witness stand. And to have a process to obtain witnesses in your favor, right? To be able to do that as a defendant, and to have assistance of counsel, which in today means that for indigent defendants or poor defendants, that the state provides them with public defendants. That comes out of the Sixth Amendment. The Seventh Amendment is, it comes out of the debates over the Bill of Rights in the sense of, particularly amongst anti-federalists, but others as well, that Article 3 mentions the right to trial by jury, but only in criminal cases. So they said, no, we need an amendment to apply that to civil cases. That they shouldn't be any different. So suits at common law, we're talking about lawsuits between private parties. Most of them are over, by their nature, are financial, right? Is to say that's why they have to be over $20. That's, in other words, there has to be a controversy at hand between private parties, but it's not about putting someone in prison. So Kerry, you asked me before about the difference between criminal and civil, and it's in those cases too, you need to have the right to trial by jury, because it was thought to be so essential that there shouldn't be a difference between the two. Eighth Amendment,
one of my favorites.
We talked about cruel and unusual, but that's also excessive bail and excessive fines. I liked what we talked about earlier today, which is to say that that language of cruel and unusual in particular is moral in many ways as opposed to strictly legal. So it asks a question of the society itself that is implementing this amendment. So that makes it interesting in terms of what it says and what it demands.
Yeah, there's always something about the amendments when amendments or the laws, when they're written like this, they're going back to like the people and saying, where's your bar? What's your level? And so there's this mix between popular sovereignty and the law working together to say it cannot be cruel and unusual, because that can be defined different depending on what year you're in. I mean, well,
and keep in mind that the fact that this came from the English Bill of Rights itself, England had a common law system, and so no one needs to know specifically what that means, other than to say that in a common law system, you are constantly changing according to precedent and prior law. So it's a system of flexibility. Therefore, moral imperatives are part of the common law.
Ninth Amendment.
Yeah, Ninth Amendment, 10th Amendment. And go to our scholar Kurt Lash for some of the way we read this, and that's to say popular sovereignty is here. So when you read the Ninth Amendment, one way of understanding, many scholars believe, is that it protects natural rights and these unenumerated rights. But the other thing it says is, okay, it says enumeration of certain rights shall not be construed to deny or disparage others retained by the people. Well, remember what I said from even Hamilton, right? This notion that under popular sovereignty, we the people in the preamble, the people themselves gave up power to the federal government and agreed to it when they ratified the Constitution, but they retained all other power and rights because that's popular sovereignty, right? The people are the ultimate authority. And so therefore, this was also a protection of that authority and the limitation, therefore, of the powers granted to the federal government, which leads us to the 10th Amendment, right? You think of these in tandem, that yes, the 10th Amendment is talking about the reserved rights of the states that were not given up to the federal government, but also not just reserved to the states respectively, but to the people. So again, right?
Popular sovereignty again.
This is the argument of Kurt Lash, and I just think it's a really good one, which is that read the text to understand how people thought in 1789 about these concepts, that they would have understood popular sovereignty was being worked into there to remind everyone reading this that ultimately we the people are still the holders of ultimate power, and then that therefore the Bill of Rights itself was reflecting that.
And you know how I like to end whenever we get to "and the people hold power." we always like to say the Constitution, powered by we the people.
Yes.
So students, I'm going to drop a couple things in the chat for you right now. One is our Friday guest speaker, which is Akil Amar, and Warren has already come up with a great question for Akil. But Nick, we're going to try it out on you in a second. And also number two, here is your modern for your students in class today. This is what, if you have time after class, we want you either with us or with your peers to ponder this question. Can the governor of a state ban gatherings of 50 people or more? We think about this, we're thinking about the First Amendment, freedom of religion, freedom of assembly, or does that violate the First Amendment's protection of freedom of assembly? And there are so many ways to answer this. So we want you to land and kind of ponder all these amendments, but also the First Amendment, but realize that it's not 203 or almost 230 years ago that these amendments apply today.
Oh, we're coming up on the anniversary in December.
Yeah. And so we have a lot of ways that we look at these amendments as alive today. So with that note, we're going to wrap up class, but we're going to hold class if you can hang out with us for some questions after class. So Nicholas, thanks for running through that so quickly. It was really fun. And I love the Kahoot, or the kazoo is what you call it.
Oh, I'm sorry.
It makes me laugh.
Whoops.